What you know, Alibis? Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. It is Friday, January 24th. Hope you guys are having a good morning so far. I actually recorded part one last night, but when I went to edit, found out my mic was on mute the entire time. Threw my hands up, went to bed. We're going to get this out today. I'm going to split this into two separate episodes, mainly because the motion for the Franks hearing was pretty lengthy and it was very interesting. I didn't want to leave a lot out on that. So look for the second episode at some point today. Also, they're back in court this morning. I'll be live streaming. I'm not sure how much of today's hearing will actually be live streamed to us, but I'll have the feed up for when they do come back. We're going to talk about the argument for the suppression of the investigative genetic genealogy. They call that IGG, which throws me off because I'm Gigi and it feels really weird to say that. But what is the IGG process? It often starts when DNA found at the scene of a crime doesn't yield results through standard law enforcement databases like CODIS. They take certain parts of that DNA, which they call a SNP, and they run it into consumer DNA sites looking for possible relatives of the suspect DNA. That is what the FBI did in this case. And then once they had a match, they submit the results as a tip back to law enforcement. So, just a reminder, they found touch DNA belonging to Bryan on the knife sheath, which was found near one of the victims. The defense goes on to say the court should suppress the IGG and everything that flows from it. There was no warrant for several phases of the investigation that led to the IGG work. She talks about the three stages of the investigation. The first, the Idaho State Police Forensics Lab moved a DNA sample to another lab to develop a profile to run through genetic genealogy. The second, that was transferred to the FBI to try and identify a suspect. The third is when they took the trash from Bryan's parents' house in Pennsylvania. There was no warrant for any of these, and that's what the defense thinks should be suppressed. The identification was done in secret behind closed doors, and that should raise red flags to your honor about privacy interests at stake. There's a lot of things that don't say how Bryan was identified, and that's because nobody wants to talk about it. That search was made by a profile that didn't lead anywhere. So the FBI took over, and we have no idea what they did. We've had several motions to compel with little information. We've learned of policies with the lab we were told didn't exist, but we've heard about them today. We don't know who did the work in the FBI. The judge asks if Bryan's DNA was matched through him personally, being a customer of one of the DNA sites, and the defense says it was one of his ancestors. They work by looking for shared DNA. But the judge says if my relatives want to upload their DNA to a site, should I be able to stop them because we share DNA? The defense says if someone takes your DNA and uploads it, you have a privacy interest. You're assuming the DNA was taken lawfully. The judge asks, why would I have a standing to object to the search of other people's DNA because I'm distantly related? The defense says the work was done unlawfully and there should have been a warrant. This wasn't a lawful process and it was in violation of his rights. And the judge asks how and says that her position isn't well supported in law. If he went in and committed the murders and left DNA, you're saying he can object to that evidence being searched for identification purposes? There's no case that concludes that, and it seems like an extreme position to take. The judge asks, how is this any different than latent fingerprints? She says this is a different search, but the judge says he can't find any case law that says a warrant would be needed for DNA left at a crime scene. The defense says in their briefing, they cite to the court some cases to support their argument. The judge points out it's one concurring opinion in a case that held otherwise. She moves on and says she wants to talk about the illegal searches, and he asks, what illegal searches? And she says it's not the forensic evidence taken by the Idaho Forensics Lab sample, which was given by the police, developing a profile and then uploading that into CODIS, which produced no results. I'm talking about the next set of moves that are super secret. A portion of the DNA was taken and searched to create a SNP. When that doesn't work, the FBI says we'll search the SNP ourselves. The judge asks about the search going from legitimate to illegitimate, she says the case they cited in their briefing, which is the Davis case, is on point. So the judge asks for those citations and she points those out and says those are the three areas we believe there should have been a search warrant and there wasn't. There is an expectation of privacy in one's DNA that society is willing to recognize. I've talked to the court about things in this case that were super secretive. We got to where the FBI SNP profile was 2 times as big as the previous labs, and they went into databases they weren't allowed to. The judge asks, how is that a constitutional violation? And she says it goes back to privacy. It's important to determine if it's a constitutional violation. There has to be a warrant to search this type of thing, and there wasn't. Some of the IGG databases changed their terms of use, and the judge says that wasn't his question. Did Kohberger submit his DNA and say, I personally don't want law enforcement to look at it? But the defense says that's not how we should look at it. We're here because the state alleges a single piece of evidence ties Bryan to this case. He's been incarcerated for 2 years facing capital murder. And I'm not sure unless we're shifting the burden to me. So, what else can I say? But the judge points out you do have the burden to show the items should be suppressed. The defense says it was a warrantless search with no justification. But the judge says that's assuming a search warrant is required for this type of inquiry. The defense thinks it is based on third-party doctrine case law. She also mentions the AT&T phone records being searched. That's part of what they want thrown out. That comes in the next episode in the argument for the Franks hearing, but she did mention that in this argument. She says with that, there was no warrant. There is an expectation of privacy. But the judge says, I struggle with there being any expectation of privacy by someone who leaves DNA at a crime scene. And that DNA, as you say, can't be searched without a warrant to establish identity. The defense says, I don't think we can go out of our house without leaving DNA everywhere. And the judge says, well, not to go to a crime scene. She says, how something gets somewhere is the subject of the trial. If you can search everyone this way without a warrant, it would erode the Fourth Amendment. And the court should look at the Fourth Amendment, the expectation of privacy, and the 3 warrants that were not given. The FBI went into 2 other databases and searched those. But before that, there was nothing else happening. The court needs to look at how secretive it was. And there's a reason, because there's a violation of privacy rights and says the IGG evidence should be suppressed. The state gets up. The judge asks, should I permit evidence obtained by searching databases that by its own policies, law enforcement said they wouldn't search? The state says the terms of use on these websites, it doesn't affect the Fourth Amendment. And Bryan doesn't have standing to raise a violation of the terms of use. And even if he did, the remedy isn't a violation of the Fourth Amendment. The judge asks if there is something in the terms of use that says, I don't want it shared with these people. And the state says, when you share this with millions of people, there's no reasonable expectation of privacy. And the Idaho appellate courts have found we give up expectation of privacy when this is shared with millions of other people. Bryan hasn't asserted he was a customer of any of these databases. The defense is picking and choosing this chain, but where did it start? At a quadruple homicide, at the crime scene. There's no reasonable expectation of privacy. The case the defense cited, Davis, is a unique set of facts. There was a shooting, and when the officer went to the victim's hospital room, he saw a bag of clothing and took it because it was a plain view exception to the warrant requirement. Later on, the victim becomes the suspect, so they test it. The district court's opinion stated nothing about this holding is indicating the government needs a search warrant to get crime scene DNA. The Achilles heel in their argument is there's no case anywhere a DNA analysis restores a reasonable expectation of privacy. The state cites another recent case from Arizona where the Supreme Court ruled about collecting DNA from someone who consented to testing 2 vials of blood, but says the case would have come out differently if the 2 vials of blood were found at a quadruple homicide. A reasonable expectation of privacy is ownership, possession, control, and the ability to regulate access. Bryan had none of those things with respect to the DNA on the knife sheath. This is a house where he has asserted he has no connection to or to the victims. And this wasn't found in a drawer. It was found where four people were murdered. And the defense can't cite any case law. So they skip over it and say, let's talk about the DNA analysis. It didn't reveal any sensitive medical information. And their own expert said he's developed these and he never sees medical information. He said it would be a lot of research to do so. The question under the Fourth Amendment isn't what could law enforcement possibly do with this, it's what did they do? They didn't look up any medical information, they looked up ancestry and mentions that DNA and fingerprinting are okay as long as it's limiting its activities to identification. And that's what we have in this case. You can't use the Fourth Amendment to say that may be my DNA, but I don't know how it got there. They're trying to get the best of both worlds. Bryan's trying to say this isn't my DNA and the state can't prove that, but he's also saying he has a Fourth Amendment standing, but that's not how it works. The state moves on to taking the trash. They mention an Idaho Supreme Court decision, Palooza, which is recent, and it rejected the same reasoning, and this court has to uphold the Supreme Court decision. I looked up this Palooza case. It had to do with them taking trash during a drug investigation. Inside the trash can, they found drug paraphernalia and evidence of drugs, so they got a search warrant based on that. The defendant in that case argued taking the trash violated his Fourth Amendment rights. The Supreme Court ended up and ruled the defendant has no reasonable expectation of privacy in items deposited in a public area, conveyed to a third party for collection, and readily accessible to animals, children, scavengers, snoops, and other members of the public. The Supreme Court upheld his conviction and rejected the arguments that Bryan's defense is making. The state says it wasn't clear where the garbage cans were, and they thought maybe they went into the driveway to get them. The judge points out the sanitation department collected the trash for the FBI in a prearranged agreement. The state says it's telling the defense did not provide the court with the documents they say aren't clear. So the state looked them up and said the garbage cans were at the end of the driveway. They also watched the body cam footage of them taking that trash, and the cans were where you would expect them to be for collection. The defense is saying a lot of secretive stuff happened, but that's not enough. You have to present evidence and you have to show proof. In this case, the defense has gotten a lot more information than in a lot of other states where there was an IGG investigation, but it's nothing more than a tip to law enforcement. That's not our case. It's not the evidence we intend to use at trial. The IGG was used and it pointed to the defendant, but it doesn't mean it violated the Fourth Amendment. The judge asks if the FBI violated Bryan's rights, would that be a burden to the state? And they say yes. At this point, the defense gets back up and says the state is burdened by what the FBI did. The secret actions they took show you there's an expectation of privacy society is willing to accept. It's interesting to hear discovery requests and motions to compel and orders have been complied with when I've heard three new things preparing for and being at this hearing today. She talks about the trash and said when you consider that area had an ordinance that trash has to be collected by a trash collector. And in that case, the FBI worked with a trash collector. The judge says the expectation of privacy is lost when you put trash into a can to be taken away. And that was the Supreme Court opinion. Even if it's a well regulated neighborhood by ordinance that says when and where you have to put your trash. She says there's an expectation of privacy when you have to put your trash out in a particular manner. The judge says if you're saying the Supreme Court was wrong and you're saving that for a higher appellate court, the defense interrupts and says she doesn't always agree with the Supreme Court. And the judge says, but I have to follow what they say. The defense says I have to make a record when I don't agree. She moves on to the Department of Justice policy and she cites the FBI isn't supposed to search databases that they're not allowed to. And in this case, they did with two of the four. and things have to be kept in a case where there's a prosecution. The results from the FBI is supposed to be a tip, but they're also supposed to keep things in case of a prosecution. The secrecy takes it out of being a tip. You have to have reliability. But how reliable is whatever the FBI did to come up with this profile and whatever else they did? You should consider that like you would any other informant in a case. She moves on to the subsequent searches after the IgG results. There is a second and third search for the SNP files after the STR profiles are developed and put into the CODIS database. As far as the subsequent searches, she said, I don't think if we say CODIS is fine, then the other is fine. The SNP uploaded in MyHeritage, it doesn't tell you personal health information, but for $12, you can get it. The potential is there. Essentially, the defense is saying there are several issues with Bryan being identified through the online genetic genealogy websites. And they're arguing that it's infringement of his privacy because his DNA was uploaded and he didn't consent. But we've seen a lot of cold cases solved just recently when law enforcement does just this. Also, arguing that his sensitive health information could have been revealed, and that's a privacy issue too. So that was it for the motion to suppress the IgG evidence. The judge did not rule on that yesterday. So we'll see what happens. On the next episode, we will cover the Frank's motion. That one will likely be a little longer. Look for that one later today. Hope you guys have a good rest of your afternoon, and we will see you soon.